Good afternoon, everyone, and welcome to the CSOS information session. We're very excited about it. I have muted all of you just to keep the session flowing, but please use the chat box if you have any questions for Johlene. And I'm going to share our social media links, which is Facebook, LinkedIn, and YouTube in the chat box. Please remember to follow us on these sites because this is where we give our information out first. The session is being recorded and will also be shared on these sites. Thank you, Caieta.
Welcome, everybody. It's good to see such a good turnout once again. CSOS is one of those topics that we kind of knew was going to be well attended. But before we kick off, I'd just like to thank Arne for all the hard work she does in the background, making all the arrangements for our community conversations and getting all of our speakers together, questions out to all the necessary people, backgrounds done, so on and so forth. We don't say enough, so thank you very much. I'd also like to thank Johlene for joining us today and taking the time to teach us and educate us and inform us on CSOS and everything that CSOS does. We have received one question before the session started, and I'm sure Johlene will be touching on that question and answering some of the concerns that were raised in the email when she starts off now with her presentation. We do have a couple of questions for Johlene after. And please feel free to submit your questions in the chat box. We will revert back to them after we have heard from Johlene and asked her some questions and she's given us some feedback so that we can obviously ask Johlene to touch on some of your concerns and queries. All right. So I'm going to now hand over to Johlene. Thank you so much, Johlene. Welcome, welcome. You are going to kick off with the presentation. Looking forward to it. Thank you so much.
Hi, everyone. Thanks so much, Caieta. I really appreciate it that you invited us again today for one of your sessions. Good afternoon, everyone. I'm going to share my screen and I'm going to talk to you about unconstitutional rules today. You're going to indicate to me when you can.
Johlene, we can't hear you.
Oh, I unmute. Afternoon, everyone. And thank you so much for the opportunity of welcoming the CSOS back. Can everybody see my screen?
Yes.
All right. So I'm going to stop my video so I don't bore you with my face. And then I'm going to take you through unconstitutional rules today, specifically for homeowners associations. All right. Unconstitutional rules, and I am going to take you through that. So remember, unconstitutional rules comes from the constitution of our country. Our constitution is woven through the very fabric of our daily lives in our community schemes, and this is often seen in the rules of our schemes. It's inevitable, though, that some schemes will try to register rules that do not pass constitutional muster, and I'm going to discuss 3 rules today. The presentation aims to provide you with a clear guideline of what is undesirable, non-compliant, and unconstitutional. These rules apply to all community schemes. However, our focus today is on homeowners associations. Now, I received a question from Caieta about domestic staff, and we can chat to that and we can have a look at that. Remember, domestic employees and staff members, it's the same as that you are an employee or a staff member, and that comes from Section 23 of the Constitution of our country that states that everybody has the right to fair labor practices. Where rules we often find is domestic staff members are not allowed to receive visitors, not allowed to talk to one another, or not allowed to walk and talk on the common property or around the community scheme without a name tag or a pass, or not allowed to walk at all, or in this instance that directors may refuse a domestic worker entry to the common property. So basically they are confined only to where they work, perhaps say it is a residence, or say it is a gardener. So they're not allowed to talk to anybody. They're not allowed to sit in the park and enjoy their lunch. They're not allowed to have their tea there, for instance, or whatever the case may be. And we should always ask ourselves, is this rule fair? No, it's not, because I already gave you the provision, and it's Section 23 of the Constitution. So if any of your rules in your HOAs, in your MOIs, in your rules looks like this, it is unconstitutional and it will not pass constitutional muster. That this is discriminatory and contrary to the constitution of our country. So please keep that in mind. Think of yourself as a staff member, as an employee. Are you allowed to eat your lunch in the cafeteria? Are you allowed to have a tea break? Are you allowed? Must you wear a name tag at work every day? Must you, or even we can go so far as to say, and we can discuss that. I know it was one of the questions, and we can go into depth of it. Can a domestic worker stay over? Now, that on the other side can be decided by the homeowners association. There can be a meeting, and if the majority says that we feel that domestic workers should not sleep over, the CSOS is going to ask the rationale behind that and the reason, but that rule will be allowed if the majority agrees on that, but not anything else, as I mentioned here now. And there's case law, and we always back it up with case law. So you'll remember the Mount Edgecombe appeal case matter versus Singh. Now, that was about the speeding in the estate, and went to the appeal court, and we are allowed to monitor the speeding in the estate. But there was another very important component in that case law, and that was about domestic workers and the rules regarding domestic workers. And what was happening in Mount Edgecombe down there in Mklanga, the rules restricted the hours of employment of domestic employees and or restrict the rights of such domestic employees to cross the public road network. The applicant, Mr. Singh, then complained that domestic workers may not walk around freely and that the residents are routinely fined for misdemeanors. So obviously the owner gets fined if the domestic then transgresses the rules. According to the rules, domestic workers may only walk through the estate when the bus from the entrance to the homes of their employers is unavailable. If they are found transgressing this rule, the homeowner is fined. In the judgment, the KZN High Court correctly declared that these so-called domestic rules are unreasonable and unlawful. So please keep it in mind when we're dealing with domestic workers. Another unconstitutional rule is the slaughtering of animals. Section 31 of the Bill of Rights states that anyone can practice their religion or cultural beliefs, and the community schemes are not excluded from doing so. So, for instance, if your rules by majority of your members state the slaughtering of animals for cultural or religious purposes are prohibited. But Johlene, then you say, but Johlene, we are 10 members in this HOA and all 10 agreed that the slaughtering of animals is prohibited. You are not above the Constitution. The Constitution says you're allowed to slaughter because we get it from Section 31. So this rule's not fair and it's unconstitutional. There is a terms and conditions, and we will go through those terms and conditions. So the legislation states that this rule cannot be prohibited in terms of the Constitution of our country. And now we're going to look at the conditions. This is the condition. So if I want to slaughter an animal in my yard, in my HOA, this is what I have to do. 2 weeks written notice must be given for the intended religion or cultural event, requesting such ritual slaughtering, the date and time of when I want to slaughter, what type of animal are going to be slaughtered, the name and the qualification of the person registered by the relevant authority, because remember, you must be registered at the municipality to perform the slaughtering. When will this animal be brought onto the premises? When will it be slaughtered? How will it be slaughtered? When will it be removed? Is it in terms of the bylaws? You must have a notice of the local authority that you complied with the bylaws. The SPCA must be there to ensure that the animal slaughtered will not endure unnecessary pain and suffering during such slaughtering. Then, very importantly, there's neighbors around us in an HOA. You must give notice to the adjacent units. You must not ask their permission. You must tell neighbor 1 and neighbor 2 and neighbor 3, I'm going to slaughter on this day, got permission from the trustees and everything is in order. What happens if you fail to comply? Then you can be penalized. Then there can be a penalty added to your statement of account. It can say, Johlene, you did not follow the prescripts. You brought the animal onto the premise. You slaughtered it. You didn't ask the directors or the trustees permission. Here's your fine. Remember, very important to add a fine provision to the HOA scheme governance documentation. State agents, it's another one. Only a certain estate agent might let or sell a unit in the scheme. Legislation. This rule imposes an unreasonable limitation on the rights of an owner in the scheme to market, sell, and let his or her unit or house through an estate agent of their choice. And the CSOS will certainly not register a rule of this nature. Schemes, and this is common in HOAs, can however request that only estate agents registered with them can conduct business with the estate agent. The question you need to ask yourself, what if this estate agents refuse to register? In my opinion, it is reasonable for the estate then to say, estate agent A, you are registered, great. Estate agent B, you refuse to register, you refuse to comply with the rules of this complex. We cannot let you sell or market this property. But that's, that's a subjective question that needs to be evaluated case by case. Another thing is about the rules. Let's talk about it. It does not pass constitutional muster, and it was struck out by the CSOS. This is the questions you need to ask yourself when drafting your rules for your HOA. Is the rule reasonable? Does it apply equally to all owners, occupiers, domestic workers, visitors, guests, everyone? It must apply to all of us. We cannot exclude a certain category or say only this is for a certain category. Members are allowed to do this, but visitors and domestic staff cannot do this. Does it unreasonably discriminate against a person or classes of persons? Very importantly, we had rules in the past, no pregnant women in the complex. Now, you might laugh at that, but people make these type of rules, or no colored people in this complex or in this estate, Do not think if it's passed by the majority, it's legitimate. It's not so. It needs to go through the constitutional test. It needs to go through the unreasonable and undesirable test of the CSOS. And does this rule have a legitimate purpose? Just think about it. We often ask questions. Say, for instance, and I go back to domestic workers. The domestic workers must wear a uniform and name tag at all times. Why? What is the purpose of wearing the name tag? Ask yourself these questions. And yes, if there is a legitimate reason, we can look at it, but it sounds very much like the pass they had to wear in the apartheid. You have to wear your name tag. You have to have your ID with you. Just think about these things. Should the proposed rule meet the aforesaid criteria, it should pass the constitutional muster. The quality assurance of your homeowners association documentation. Now let's keep this in mind, that the CSOS is the regulator of all community schemes in South Africa. There's 5 types of community schemes. There's sectional title, there's homeowners association, which include non-profit companies as well as common law association. It includes retirement villages, it includes share blocks, and housing cooperatives. So it is not a sectional title regulator. And we find that in Section 4, Section 1 of the CSOS Act explains what I just told you, the 5 types of community schemes, and then Section 4 says what we must do. Now, all scheme governance documentation must be quality assured by the CSOS. We regulate, monitor, and control sectional title governance documentation and other governance documentation. However, it is not a must to submit HOA governance documentation to the CSOS because it first needs to be gazetted. However, it's good to do so, and I'm going to take you through that process today. We have a specific form for homeowners associations. It's Form B1. Form B is for sectional title. What are you going to submit? You're going to submit your rules, your articles, your MOI, your constitution, your conduct rules. You're going to submit the resolution signed by the scheme executives. We hereby, the scheme executives of so-and-so HOA, we convened a meeting. This is the percentage that had to approve the rules. The rules were approved. We send it to the CSOS, and you submit the signed minutes of the meeting. Now, Johlene, you're going to say, but the minutes is only approved at the next meeting. Yes, we know that. Just let your scheme executive sign the minutes, not approve it, because it's always going to be approved at the next one. Just sign it off, send us the minutes, and then we're going to quality assure these rules. You're going to submit it to this email address for HOA. It's hoagovernance@csos.org.za. I'm going to share this presentation with Gita, and she is going to send this to you. We allocate rules on Mondays to our attorneys, our scheme governance officers who quality assure these rules. For existing rules, it's 30 days. For new developments, it's 1 week if there needs to be a register opened in the deeds office. And that's really the process for quality assuring of your HOA documents. Remember, we have extracted all the provisions, if you're a non-profit company, out of the Companies Act. And we have placed it in a template, not in a template. This is a skeleton template. This is by no means everything that possibly can be in your rules, your architectural guidelines, etc. So if you would like, we will give you a copy of that free of charge. Everything we do is free of charge at the CSOS. There is no charge for anything. All we ask you is to pay your CSOS levy. If you are not going to waive your CSOS levies, because remember, we waive CSOS levies as well. So please keep that in mind. The CSOS provides free training, education, and awareness. We often work with CAISA and Gita and Johlene, where we go to community schemes, homeowners associations, where we address the members, where we address the board of trustees, where we address the trustees with all training requirements. Our training is bespoke, so it's specific to your HOA. It's not a one-size-fits-all. If you're not sure what provisions you have to deal with in the Companies Act, we take that for you. We advise you how to conduct your AGM, what needs to be quorum notice, what does the Companies Act say, what can your MOI say, so anything you would like, the CSOS can assist you with. And then at the end of the day, if we have quality assured your certificate, your rules, you'll get a certificate like this. Now, obviously, your certificate will be in terms of Section 4 of the CSOS Act. This is now just an example of a sectional title rules, but the certificate's going to look the same. It's just going to say Section 4 certificate for Villa Rosa HOA, signed by the Chief Ombud. And then you have a compliance certificate, because we check your rules against the Constitution, the bylaws, undesirable rules, and the CSOS Act and the regulations, of course. And that is my telephone number, ladies and gentlemen. That is my email address. As I said, I'm going to send you this presentation. You are then welcome to refer back to it. And yes, that was my presentation. And thank you very much. Thank you, Gita.
Thanks a mil, Johlene. That was very informative. It's answered some of my unanswered questions. So I've recently had an application to do a slaughtering here where I manage my estate. So thank you. It clarified a number of things that I was uncertain of. I've just got one or two things based on that, just for your interest. I did communicate the list of requirements to the resident concerned, and I, funnily enough, received an email from the SPCA stating that they are not aware of this requirement. So I actually informed them that they should possibly make contact with CSOS to make sure that they are informed of what the requirements will be. All right. So if anybody else has got any questions on that, you've got Johlene's information, please. She's quite friendly. She's very helpful. She's always been very helpful in cases where I've made contact with her. So please feel free to make contact with Johlene. She's dying to assist. Okay. All right. Thanks, Johlene. The next thing I'd like you to tell us about, please, is the CSOS Connect.
Thanks, Gita. Yeah, we are super excited. The CSOS are embarked on procuring a service provider in January of this year, where we are going to develop and build our own systems. We call it the CSOS Connect system. So we're talking about CSOS Connect. That's really what we're talking about. So the first phase that we are developing is the registration phase, where you have to register community schemes. Say you're a managing agent, for instance, and you have 50 schemes to register. Normally fill in the CS1 form and we register it for you. Now it's going to be a self-help platform where everything is going to be in your hands. It's seamless. If you think of online shopping, you just click a button or a drop-down menu appears. It's going to be like that. It's seamless. It's fun. It's interactive. You're going to be prompt along the way. It's going to take you 5 minutes to register. You're going to see an entire portfolio of your HOA, say when you've submitted your annual returns, the levies that you've paid, who's members of the community scheme. This is now for the scheme executives to see, of course. You are going to see who, if the directors changes hand, you're going to fill in that form. You're going to populate it onto the system. system, everything that you're going to see. If you've lodged disputes for that specific HOA, you're going to see it online, the rules that you've submitted, if you would like to submit new rules. So it's really a dashboard of everything in your HOA or your managing agency or any other type of community scheme. We're also interacting with service providers that provide services to you as an HOA or community scheme, that they can, from their perspective, also provide input. So we have a whole spectrum of our target audience, and that's everybody that's interested in a community scheme, from a developer straight down to the accountant, the managing agent, estate managers. Of course, we have a pilot that we've launched in August where we've shown a select few what it's all about. So if you would like to be part of that, just pop me an email. We can put you on board to the pilot session. You're going to actually test the system in the beginning of November. That's very exciting. So you're going to put on your cap to say, I'm an estate manager, or I'm a director, or I'm a member, and this is how I can interact with the system, and then then obviously test it and tell us what you think and does it work for you. So that's very exciting. So we are launching first phase end of November, but obviously not before interested parties are actually testing the system in the beginning of November. Yes.
Well, that's great news. It sounds very convenient and efficient. So well done to CSOS for taking the initiative to get that platform out. I suggest everybody make contact with Johlene and put yourselves up for that pilot test, and make sure that you get involved, because at the end of the day, it doesn't help we complain after the fact. We need to be part of the initiative to get the system working for all of us. All right. So I'd like to motivate all of you to get involved. Johlene, please can you give us some insights and information on the training that CSOS has been hosting? You know, I very often see a Facebook post with them in Natal or in the Cape or here up in the Northwest, even Gauteng. I unfortunately missed one of the training sessions, and I'm very, very eager to attend one of them. And I'm hoping that we can, at least last time, unfortunately, I think they just notified us too late, or they didn't have my contact detail. But can you give us some more information about the training courses that CSOS hosts? Is it a variety of courses? Is it a set thing? And how do we get involved other than having to look on Facebook? Is there a way in which we can be informed directly? Because I'd be very interested in attending most of the stuff. So if you could just give us some insight on that, please.
Thanks, Gita. No, definitely. You shouldn't see it on Facebook. You should be personally invited. So the first thing to do is to get on our database. You need to get on our database because we share articles, we share our newsletters, we share YouTube videos. We tell you when our training is. We have a roadshow that starts next week. I think it's Rustenburg, Polokwane. We're doing Pietermaritzburg, we're doing the Capes, we're doing Northwest. So you need to get on our database. So what you're going to do, you are sending an email to either myself or training@csos.org.za. Say, please add me to the database. You can opt out of it any time. So what we've done now, obviously there's over a million property owners in South Africa. So we can't send out 1 million different emails. So we have now got bulk email services. So with a click of one button, we can reach 1 million stakeholders. So our database is not yet 1 million, of course, but it's 50, 60,000 we can reach at the same time. So get onto the database, and then let's get you going with that. And then our training, as I've mentioned, is bespoke. We do the roadshow training where we advise on AGMs, trustees' responsibilities, directors' responsibilities, anything else, the fiduciary duty, conflict of interest, that often happens. What does the Companies Act say about it? Really anything. But if you want us specifically to come to your HOA, we do bespoke training. So Johlene, we've got these questions, we've got these queries, and then we dedicate our training regarding that and around that. We don't do AGMs, we don't attend your AGMs or SGMs, but we advise beforehand if you have a provision or a conflict and you say, Johlene, the MOI says this, but what do you think about this? We can provide legislative advice. So yes, our training is just give us a week's notice or so, and we'll come to you and we can do training for your entire scheme. But if you can, please attend our roadshows. we will send out the details. Just get onto our database and we will communicate that to you.
Great, that's fantastic. Thank you very, very much. All right, so if anybody didn't get that email address, it's training@csos.org.za, correct? Okay,
Yes.
Make sure you send that email so that you can at least, have the information directly. They can send it to you directly instead of wondering and like me finding it on social media. But thank you, I didn't know that, and I'm very pleased because I'll definitely be sending that email after this session. I don't have any further questions for this point at this moment. I don't know if there's anybody who's actually attending the community conversation who'd like to maybe ask Johlene a question, maybe a challenge that you have in your estate at the moment.
Sure.
Right, I don't see any comments in our chat box either. So
yeah,
looks like
it looks like
questions.
Yeah, Caieta, it looks like we've got well-informed estate managers, with no
Obviously.
issues on their estates. I must go and look for work there.
I've got a question though. I do have a question. Do you find, or have you recently found that, and this is now an estate question, sectional titles, there's very often two levies. Have you ever had challenges come to CSOS's door or to the desk of the adjudicator saying, we've got a problem. There's a sectional title within our estate. Our sectional title body corporates are challenging us around levies.
Yeah, yeah, it's unfortunately when you buy in a mixed use development, and there's an HOA as an overarching body, and there's sectional title, there's two levies to be paid, That's often not explained to us when we buy, say for instance, as a member of a sectional title development in an HOA, so it is unfortunately you're bound by the rules of the HOA and the overarching body. You don't need to sign for it. So the minute you buy into a complex, whether it's a state or sectional title, and also with mixed use developments, you are liable for both levies because you also cross the road. You also go through the boots of security. You also sign in or use biometrics, and that can't be covered by the HOA alone. So, and however, the HOA does not use the facilities of the sectional title, but the sectional title use the facilities of the HOA, and two levies are payable. And then, and that is always unfortunately so. And we are in the process and working with the PPRA, the old Estate Agents Affairs Board, to get on board and to train estate agents at the end of the day, because you'll often find it's not disclosed. Yes, there must be disclosures now in terms of the new PPRA, but, just to advise them that, it's already tough enough just to pay your bond. And now on top of that, a levy and another levy. So one must wonder about that. And we don't want to impoverish any of our clients and community schemes, but unfortunately, no one is waived from paying their levies. And there's unfortunately two levies in a mixed-use development.
All right, thank you very much for answering that question. Johan?
No, I just want to make a comment before we close. So I don't want to take the question time up, but maybe there's some more questions.
I see there is a question, if I may continue. Hi, I'd like to ask regarding levy accounts. Once a judgment has been made on a due levy account, how does CSOS assist to ensure the residents do make the payments as recommended on the outcome? If the residents do not pay, what does CSOS do?
All right. So once an adjudication order is issued by the CSOS, our role is functus officio, which means we are stepping out, we are done. However, with the adjudication order, we call what you get as an enforcement notice. That enforcement notice is a court order. You're going to take it to the registrar of the High Court if the quantum falls into the High Court scale. If it's in the Magistrates Court scale, you're going to take it to the Clerk of the Court. You don't need an attorney. It's not going to cost you money. You take that enforcement notice together with the adjudication order and you say, you know what, I would like to make it an order of court. The registrar or the clerk of the court stamps it. What you're going to do with it, then you're going to take it to the sheriff of the court. So remember, you have default judgment now against the arrear debtor. The HOA or the scheme is going to have to pay for the sheriff's fees. that is a couple of hundred of rand. You're going to take it to the sheriff, and the sheriff is going to come to my property as a rear debtor. He's going to write up my movable assets, and he's going to sell my movable assets in order to ensure that I pay the levy over to the HRA. Then that is the process that you need to follow. So with each and every adjudication order, you must ask for the enforcement notice as well. And that is the process that you should take.
Great.
And remember, at the end of the day, if there's no movable property, you go against the immovable property. And the most important question is, what if that member still refuses to pay? Remember, he's in contempt of court because you have a court order that you've stamped. All CSOS orders are the equivalent of high court orders made by a judge. He's in contempt of court. And what happens when we're in contempt of court? We get arrested and we are brought before the court. We have failed to act on a court judgment. And that is really the process.
Well, thank you, Johlene. I hope that's clarified your question. Are there any other questions? Now's your time. It's the opportunity to abuse. Nobody? Wow. Johan, they really do work at peaceful states with no problems.
Sounds fantastic. Johlene is going to be out of a job soon.
Never.
It's like a dentist. You're working yourself out of a job. Kita, what a great turnout today. I'd just like to remind everybody who's on the Zoom, please pencil in the 29th of November. It's still pending on a few things that need together, but at the day we would like to do the AGM, do another course, the ZA 210, that will be on finances, and our networking session that evening. It is currently booked to be at Pekerwood Golf and Country Club. We'll keep you posted. And in that course that we're going to do on the 29th, we're going to give another slot for Johlene. Maybe she gets some more questions than today. And then thanks for Johlene. I mean, she didn't tell us, but I mean, she just recovered from operation. So, you know, it's for her to make the time to be and spend some time with us today. We really appreciate it. Awesome. Thank you for everybody.
Thanks, everyone. Thank you so much, guys. Thank you. I appreciate it.
Thanks, guys.
All right. Thank you. Bye.
Bye.